In this class we're going to look at the legislative process in the United Kingdom. This is how we get laws in the United Kingdom. And in particular we're going to look at the role of Parliament in developing laws. From other videos you will realize that there are two types of law. One is common law and the second is statute law. And here we're dealing with statute law. Common law is what judges and the courts have developed over hundreds of years. And that's the way they interpret some cases. But statute law is also important. So there are two forms of law. And here we're dealing with legislation. Now, the government has many functions to perform. It deals with other governments and negotiates treaties and negotiates arrangements with other countries over lots of issues, energy and so on. But it also passes laws. And these laws are seen as important in the day-to-day running of the country. So it's for the government to pass laws. And these laws govern us as individuals and as organisations and as institutions in the country. Now, in order to pass legislation, the process first begins with what's known as a bill. Now, this is the introduction of a law or a piece of legislation. This is the starting point, a bill. A bill is a process that outlines the scope and intentions of the law or the legislation. So it's a draft of what has been proposed. It's an outline. The bill is scrutinised by members of the House of Commons. The House of Commons is the main law-making institution in the country. There are two parts to Parliament, the House of Commons and the House of Lords. The House of Commons is elected in general elections or by-elections. And because it is elected, it is the most powerful institution. The House of Lords is not elected, and therefore it is much weaker. So the bill, the proposal for the law, is scrutinised, it's checked over by members of the House of Commons who make recommendations, object to it, and some people approve it, and it's the majority view that will be carried. If the majority of the House of Commons agree, then the piece of proposed legislation will carry on to the next stage. It then moves to the House of Lords for further debate. In the House of Lords, although they're a much weaker institution and they're not elected, they do serve a purpose of debating the law to see if they can improve it, make it better through debate and through discussion. And if it's approved by both the House of Commons and the House of Lords, the bill will be sent for royal assent and then transforms the bill into law. So essentially that's how law comes about. It starts as a bill in the House of Commons. It's proposed, let's say, by the government, the leading party, the main party in the House of Commons. And if it's passed in the House of Commons, it moves to the House of Lords. The House of Lords will debate it. If the House of Lords disagree, they can delay the bill. They can't stop it because the House of Commons is more important. But they can delay it. They can hold it up. And after it's been passed by both houses, it goes to be signed by the Queen, and at that stage it's transformed from a bill into law. Now in a nutshell, that's how laws come about. Let's look at the House of Commons in a bit more detail. It's publicly elected, which provides citizens with the ability to vote for individual MPs, members of Parliament, to represent their political party. So there are different political parties. There is the Labour Party, the Conservative Party, the Liberal Democratic Party, there is the UK Independence Party, and so on. There are many parties. And MPs seek to be elected because of their views. And when the House of Commons meets, the parties with the biggest number of supporters become the government. Now, the party which has the most members of MPs form a government that controls the legislation in Parliament. It introduces the bills that ultimately become law. Now, the political party has a leader. The main political party has a leader. Well, they all have leaders, but the main political party which has a leader becomes the Prime Minister, the First Minister, the Prime Minister, who enacts the bills into law, who moves the bills into law. And it's through the debate and the discussions in the House of Commons which have improved the law, then moves them into the House of Lords for subsequent ratification. The House of Lords, well, the House of Lords' function is to initiate bills as well and evaluate the credibility of bills sent from the House of Commons. So the House of Lords can introduce its own bills and move them back to the House of Commons, where they may be approved or not. But they must be approved by the House of Commons if they're going to become law. But the House of Lords does get to scrutinise the bills and coming from the House of Commons, so they can make recommendations for improvements. In the past, the House of Lords was the highest court of appeal. All the powers in this regard have now been transferred to the Supreme Court. But in the past, there were certain members of the House of Lords, certain lords, who had an expertise in law. And they became the final court of appeal in the country. They're the ones who interpreted common law and also oversaw the whole legal system. So if there was an issue, a major issue of law, it would be referred to the House of Lords, to that section of the House of Lords, I should say, that deals with those issues. Now, all of that since 1989 has been transferred across to the Supreme Court. The monarch is responsible for selecting the Lords, who is then responsible for overseeing the progress of bills and the legislative process. So the House of Lords is appointed by the monarch. Now, the types of bills. Well, the government is seen as dominant in passing legislation, as it holds a responsibility to govern the country. So it's the government who sets out the bills and makes the proposals. Besides the government, there are other members of our bodies that can initiate a bill, and if successful, they're transformed into legislation. For example, the House of Lords could, or a private member of the House of Commons, a single member of Parliament may propose a piece of legislation. Or it could be proposed by some local authority, some local government, some part of the country who wants a particular law passed for that particular part of the country. So it's not just the government, but it's, in the main it is the government. In the main it's the government who propose legislation. But it can come from other sources. Now, government bills. Well, bills introduced by the government are most likely to be successful, simply because the government has got a majority of supporters in the House of Commons. They've been elected by the people, so the chances are they're going to get their legislation through. It's going to be approved. The role of the government is to dictate the legislative calendar in the House of Parliament. So it's the government who sets out what laws are going to be passed. These are normally done in the Queen's speech, which is the opening of Parliament. When Parliament opens, the Queen goes along to address both houses of Parliament, both the House of Lords and the House of Commons, and the Queen reads out what legislation is going to follow. And that has been put forward by the government. Now, as I said earlier, it can be private members' bills. A bill from an individual MP or private member within the House of Lords may wish to bring a bill into force, and this is quite common. They don't often get through, but it's common that members of Parliament and members of the House of Lords try to get bills enacted. So there is an opportunity for them to try and introduce a bill. If the bill has a lot of support, it could become law, but generally speaking, they're not very successful. Normally these bills are introduced on the basis of moral or social concern, and it normally concerns some current issue which needs to be brought to attention. This type of bill, as I said, is rarely successful, and because it stands alone. The bill perhaps does not have the support of the government, and if it doesn't have the support of the government, it's not going to get passed. It needs to have a majority of members of Parliament to support it for it to become law. And also the time necessary for it to become law may not be available. It may be a very tight schedule, and the debates on the piece of legislation could go a bit too long and are overruled and therefore all stopped because they were taking too much time. So, generally speaking, private members' bills are not that successful. You do get bills that are introduced by organisations or local authorities, usually relating to some local issue. So in one part of the country they might need a particular law just for some particular function, and that may be introduced and put through the House of Commons to become law of the land. This type of bill does not aim to make changes to the country's reforms. It doesn't. This type of bill is just normally for some local purpose. So a local government may wish to introduce some bylaw, some rule that cars can only drive in a particular way on a particular street at a certain time, and they want to make it into law. So they may take it to be passed as a law. So it's for particular interests within a local area, particular organisations, particular individuals or particular industries within a local area, and these laws may be introduced for that purpose. Now, the introduction of the bills do affect the UK. Public bills are the most common type of bill considered in Parliament. This is due to the fact that it applies to the general population. It's a public bill. It applies to everybody. The government and members of Parliament, Lords, are the main contributors to public bills. So public bills apply to everybody, and these are the main types. And the impact, as I said, on the general public, therefore, they must be carefully thought out. It's important that they're properly debated, and that's one of the reasons why there are two chambers. There's the House of Commons and the House of Lords, so that bills are properly debated. Now, let's look at the stages of converting a bill into an act. Let's see how it happens. That we started with the proposal, which is the bill, and it changes into an act of law. A bill has to pass through several stages before it becomes an act or legislation. The stages are, first of all, generating an interest. Well, there must be enough members of Parliament who agree. So It's important, otherwise it's not going to get anywhere. Then develop the first draft. Then the first reading of the bill. That's when the bill is presented. Second reading of the bill after some debate and some refining. Evaluation of the bill by some committee. Maybe a standing committee may look at the bill and may take it over and make suggestions and recommendations and changes to the bill. Then there's what's known as the report stage. That's the report of the standing committee. Then there's the third reading of the bill. Then they meet any requirements of the House of Lords. The House of Lords may make recommendations or for changes as well. So they meet any requirements of the House of Lords, and then it goes for royal assent when it's signed and becomes law. Let's look at each of these very briefly. First of all, generating an interest. A bill comes into existence when the government feels that there is a need for a certain legislation. So there must be a need for the legislation, otherwise it's a pointless act. In order to bring the bill into existence, the government needs to develop documentation called the Green Paper, in which to set out the nature and requirements of the legislation. So a Green Paper is the absolute start of the law. That's where the government sets out its ideas. So there's a Green Paper, and it's published so that members of the House of Commons and the House of Lords may see it. It's a proposal. After further discussion with interested parties, members of Parliament from the other parties, or maybe even outside agencies, different industries or trade unions or charities or whoever, after discussions with outside parties, other interested parties, the government can develop a white paper detailing a set of firm ideas and impacts of the policy. This forms a draft bill. So after the Green Paper has been published, the government tries to get opinions and feedback and soundings. It's looking for feedback from interested parties, from other MPs, members of Parliament, from the House of Lords. It's trying to get a wide range of opinion. And after that happens, it publishes a white paper, moving from Green Paper to a white paper, which sets out the ideas of the policy. And at this stage becomes a draft bill. Now, developing the first draft, well, the first draft has to be developed, which must be presented to the Parliament for consideration. So the first draft is presented to the whole House of Commons. And it must outline in detail the legislation and its requirements, the impact this will have on the people directly involved with the Act, and also the need for the legislation. Was it required? Is it absolutely necessary? So the draft must outline in detail these issues. Then after that, there is the first reading. It's the first day of presentation to Parliament, introducing the bill. So the first reading is the first formal presentation of the proposal to the full House of Parliament. In the Parliament, the bill is associated, it's allocated a number, and the Stationery Office prints the bill for the House of Commons or the Lords. So the bill is printed, and members of the House of Commons get a copy. It's given a number, which will be the where it's filed in the system, and now it's been presented. The second reading stage involves a lot of debating about the proposal. The second stage is when it's debated, and MPs may disagree, and there are arguments over the bill and proposals and amendments put down. The House considers the nature and content of the bill in more detail, and there is a chance to discuss any implications of the bill. And a record of proceedings are produced, and the initial consideration of the proposal begins. So the second reading is where there's been a big debate, but now the government can listen to the debate and hear points and perhaps amend the bill to make it stronger, to make it better, given what was said during the debate. The bill will also be sent to a standing committee. This is a permanent committee of members of Parliament, drawn from different political parties. The stage involves members of a standing committee for each bill presented to the House. So each bill for the House goes before the members of a standing committee. There are many standing committees, but it goes in front of the appropriate one. Now it comprises of groups of members of the House, including a minister from the government responsible for the bill and a member of the front bench of the opposition. So whoever's proposing the bill, the minister that is proposing the bill, will be on the committee, as will that minister's opposite number, the one who opposes that minister in the opposition. So the committee is composed of those and others to debate the bill again. Now the Standing Committee examines the bill in a lot of detail, looking carefully into each clause and schedule of the bill. So they go through it line by line. And they will have legal advice as well, advising them as to whether the bill is consistent and accurate, but they will go across each word of the bill to make sure that the bill makes sense and it is what is intended and it is consistent with other laws. The Standing Committee has the power to agree with the inclusion or deletion or deleted from the documentation. So the Standing Committee has got power. So this leads to more discussion and the possibility of including additional clauses and schedules. So generally speaking, the committee may insert points into the bill, make recommendations for points to be inserted into the bill, or to delete points in the bill, delete parts of the bill. After the bill has been scrutinised, the committee presents a report to the House, and then the committee is dismissed. That's the end of the job for the committee, so they're no longer required. But what they've done is they've gone through the bill in great detail. They've made perhaps recommendations to include certain points or to delete certain points, and then it goes to back to the House of Commons. At the report stage, this looks at clauses and schedules developed by the Standing Committee. It goes across what the Standing Committee has recommended in great detail as well. This stage makes further amendments to the bill if necessary. So at the report stage, the bill can still be changed. So the law would still be different, or could be changed at this stage. A reflection of the reformed bill, the House may accept amendments made by the committee or not. So they don't have to accept the committee, but generally speaking they do, because the committee has got an expertise and the committee has spent a lot of time with a lot of advice on each part of the bill. So the bill is further scrutinised at the report stage. It's further looked into. Only now it has benefited from the second reading in particular, which was a full debate in the House, and now from the Standing Committee as well, And now it's gone back in what's known as the report stage, when it's been looked at again. And at this stage, any final changes can be made to the bill. The third reading of the bill, the final stage of the bill, no amendments can take place. The House considers the bill, which was amended by the committee. Further debate is undertaken if necessary. Final proposal of the bill is ready to be sent to the House of Lords. In other words, the third reading of the bill is the final one. At this, there are no more amendments. It's now, it may be debated further, but it's not going to change. At this stage, it's ready to be sent to the House of Lords. Now, it must meet the requirements of the House of Lords. After the bill has completed all stages in the Commons, it is moved to the House of Lords, where it goes through a similar process. As opposed to the Standing Committee in the Commons, the Lords Committee consists of the whole House Committee. So they don't really have standing committees, smaller committees like the House of Commons. In the House of Lords, it goes in front of the whole House of Lords. And this is where further discussion takes place and necessary amendments are made to the third reading. So, the bill is discussed fully in front of the House of Lords. If all is successful, the bill is then passed for royal assent for approval. So it's passed on to the monarch to be signed, at which point it becomes law. Now, royal assent, this is the final stage in converting a bill into an Act of Parliament. Once the House of Commons and Lords have debated the bill, scrutinised its content, if the bill is agreed by both the Commons and the Lords, the bill proceeds to the monarch for royal assent. So, royal assent is the last process. In this stage, the bill becomes an act of law. So that's how a piece of law is developed by the parliamentary process in the United Kingdom. It starts with a proposal, a green paper, and then it goes through the various stages. And really the whole purpose of what is going on here is to scrutinise the bill so that it's made stronger, it's improved, and any issues are ironed out before it becomes law. So there are no problems once it becomes law. So that's the insight into how legislation is passed. And that's all really I want to say on the topic of the legislative process in the United Kingdom. So, thank you for watching.